This case starts off like many others, but don't be fooled, because what unfolds here is anything but ordinary. We've got Stephanie Sandoval already on deferred adjudication for assaulting a peace officer. Now back in court facing serious consequences for violating probation. Missing just one report might sound small, but legally, it opens the door to something massive, up to 20 years in prison. And here's where it gets intense. The judge makes it very clear that no agreement with the state can guarantee her safety. So the real question is she about to lose everything over one decision?
All right, court is calling 2018 CR 12679, State versus Stephanie Sandoval.
Morning, Judge.
Good morning. If I can have parties announced.
Jason Garrett here for the state. Nathaniel Navy for Miss Sandoval.
And are you Miss Sandoval? You need to speak up.
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Stephanie Sandoval who was placed on deferred adjudication in 2018 CR 12679 for the offense of assault peace officer judge on October 4th, 2019 for a period of 6 years? Is that you?
Correct.
Is that you? Yes or
Yes,
no?
ma'am.
State?
Yes, Your Honor. Violated condition number 5 in Bear County, Texas. Defendant Stephanie Sandoval did in there fail to report to the supervision officer as directed for the months of October, November, and December 2024 in violation of condition number 5.
All right. How do you plead to that? True or not true?
True, ma'am.
We'll waive the remaining violated condition.
No objection. No, Your
Did you
Honor.
understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Just,
Do you,
and I apologize. I thought it was a third-degree felony which she was charged with.
no,
Second.
it's listed as a second.
It is.
All right.
All right. So did you understand that? Knowing that, do you still wish to plead true to violation of condition number 5?
Right here you can feel the pressure building. She hesitates, saying maybe not, and that moment speaks volumes. Because in court, hesitation can be dangerous. The judge isn't here to negotiate feelings, he's locking in facts. Once she pleads true, she's essentially admitting the violation, and that gives the judge full power to sentence her. No deals, no promises. It's a critical turning point. So ask yourself, if you were in her position, knowing the risk, would you still go forward or fight it?
That's either yes or no. If you don't want to continue to go forward with this, then it will be set for a contested.
I'm hoping not.
No. I'm not here to figure out what your agreement is. My only question for you is, you've pled true to violation of condition number 5. Is that correct? All right. So do you understand that I can revoke you, regardless of whatever agreement you reach with the state? I can revoke you and sentence you up to 20 years in prison. Do you understand?
Can I have just a moment, Judge?
Sure.
Just a minute.
But I'm going to let the deputies take you back because they can only have so many inmates in the box. But your time, whatever the correct time is, we're going to make sure you have it today, okay? All right, thank you. You're welcome. All right, we're back on the record in 2018, CR 12679. So my question to you is, you're entering a plea of true to violation of condition number 5?
Yes.
All right. Do you understand by entering true to violation of condition number 5, the court could find it true, grant the motion, sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court is going to find violation of condition number 5 true. Is there a proposed agreement?
Yes, there is, Your Honor. It is to deny the motion to adjudicate, continue on a deferred with the amended conditions of extended for 2 years. Also, a TAP evaluation while in custody and a drug court evaluation. If she's not accepted, the state is recommending, I believe the defense counsel might argue on this, if she's not accepted, drug court safe.
And that's our understanding of what the state is recommending, Judge. I guess my understanding is we do have an agreement to extend and keep her on her probation or community supervision. We would just be asking for an intensive, monitored outpatient type situation with drug testing. And Judge, there's a lot that I'd like for you to consider.
Yes.
We can do it briefly if I could just
Sure.
swear my client in.
Oh, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right. State your name for the record.
Stephanie Sandoval.
All right, you may proceed.
Okay. Ms. Sandoval, you're aware that you've failed to report for multiple months on this community supervision, correct?
Yes, that's correct.
Okay. And can you tell us what happened in July of 2024?
Now, this is where the emotional weight hits hard. She explains that the father of her child, her partner, died in a horrific accident. Suddenly, this case isn't just about missed reports anymore. It's about grief, responsibility, and survival. But here's the reality: while her story is heartbreaking, the court looks at patterns, not just moments, and the judge is already thinking, did this tragedy cause the violations? Or were the problems already there? That distinction could decide her future.
The father of my child and love of my life was killed in a big accident, and we have a 3-year-old.
Okay. What kind of an accident was that?
A lady took her cancer treatment pill for the first time and fell asleep at the wheel. So he was ejected and he flatlined 3 times and had a heart attack.
Okay. And is his name Ricardo Arana?
Yes, sir.
Okay. And this is a copy of his obituary?
Correct.
And Judge, I've tendered this to the state. If I could just proffer to the court for your consideration.
You are counsel.
Thank you, Judge. Appreciate it.
Mhm.
Okay. And did Mr. Arana provide childcare to your daughter as well as yourself?
Yes.
Okay. And so once he was killed, essentially most of the burden fell on you. Is that correct?
Correct. My car was out of commission. I didn't have it. I was a stay-at-home mom for 3 years. My daughter was born with a medical condition. So once he was gone, I couldn't leave her at home alone because, obviously to go to the lab, you need somebody to care for your children because they're not allowed there.
Okay.
I'm not making excuses. It's my responsibility, but I couldn't leave her alone.
Okay. Have you historically had issues with alcohol?
Yes.
Okay.
And I'm not making excuses. My past transgressions. I just don't want to be her fault for her and lose both of her parents with it.
All right, so here's my question. Where is your child now? Who's taking care of the child? All right, so here's the problem the court has. One, I think inpatient treatment is the best for you because looking at the motion to revoke, I understand that you're only pleading to number 5, but I have all of these violations of condition number 2, and it's before the death of your husband using meth and amphetamines over and over, and then not submitting to drug testing over and over. So
This is at the moment everything comes down to. The judge lays out 2 stark options: 3 years in prison or a strict, life-altering path through felony drug court. And make no mistake, drug court is not an easy way out. It's intense, structured, and demands full accountability. But compared to prison, it's a second chance. The judge is essentially saying, I see the pattern, but I'm giving you one last shot. So what would you choose? Certainty in prison or a tough road to redemption?
you have a choice, and let me just tell you what your choice is. I can revoke you. I'll sentence you to 3 years in the prison, or either you're staying in the custody, you're going to be referred to felony drug court. If felony drug court doesn't accept you, you're going to safety. Those are your only choices.
Could we present you I have some things regarding the drug use to present, if that's okay, Judge.
Sure, you
If I
can.
could ask her about that.
All right.
Thank you, Judge. Okay. And so there have been positive tests for amphetamines, correct?
Correct.
What mental health conditions do you struggle with?
I have ADHD, PTSD, anxiety.
Okay. And were you taking Adderall?
Yes.
And you're aware that Adderall contains amphetamines?
Yes.
And admittedly, were there times where you took that without a prescription?
Yes.
Okay. But do you currently have a prescription for that?
Yes.
Okay. And I've tendered this to the state as well. Is this a copy of your current prescription?
Yes.
Copy this to the court as well.
Ooh.
Okay. And is there anything else that you'd like for this judge to know about your motivations, your hope moving forward, and anything about your case?
Yes. I know that drug supervision and being drug tested is imperative as well as further support. I'm currently with Continuum doing an IOP, but also the Children's Specialty Court contacted me. And I really want to work with them to try to be unified with my child, which I will also be getting drug tested 3 times a week. Judge, I made so many mistakes in my life that have kept me from doing well.
And so regardless of what happens in this court, you're going to be drug tested 3 times a week. Is that correct?
Yes.
Okay.
All right, so this is what I'm gonna do. You've been on this probation since 2019. You missed drug testing. You've been using Adderall, sometimes with a prescription, sometimes without a prescription. So you have 2 choices. I can send you to prison for 3 years, or either you're gonna be referred to felony drug court. If felony drug court doesn't accept you, you're going to safety. If you're honest with felony drug court, what I can tell you is felony drug court will accept you. It's a difficult program. They will work hand in hand with the CPS court. Those are your only 2 choices. So what do you choose?
I want to try going to felony drug court so I can try to get my daughter back.
All right, so the court is going to deny the motion. Alternate amend conditions to the following in custody. There's to be a referral to felony drug court. If not accepted, then there's to be safety. And there's to be 160 sober meetings in 160 days upon release.
In the end, the judge makes a calculated decision, a prison for now, but placing her under strict conditions: custody, referral to felony drug court, mandatory sobriety meetings, and extended probation. This wasn't leniency, it was structured accountability. The court recognized both her struggles and her repeated violations, balancing punishment with a chance to rebuild. But the outcome now depends entirely on her actions moving forward. One mistake could bring her right back facing prison time. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments too. You think the judge made the right call? And don't forget to subscribe for more jaw-dropping courtroom breakdowns.
No unsupervised contact with minors. And probation, is there anything else?
No, Your Honor.
Judge, needs to be extended.
Yes, thank you. I knew I was thinking about that. Extend for 2 years.
And just to clarify, Judge, the no unsupervised contact with minors, does that apply to her daughter as well, or is
Yes.
that okay? Because I know that there's a CPS
Yeah, there's
thing going on.
visitation, and you were hoping to reunify within 6 months to a year.
Well, that visitation needs to be supervised, and usually that's what CPS does.
It is.
But if CPS eventually at some point were to modify it so that she could have custody, would this be modified as well, Judge?
Well, she'll need to come here. A motion will need to be filed. I'll hear it. And what I can tell you is during that hearing, they can appear by Zoom, but I'm going to need the caseworker and the children's attorney if there is a child's attorney.
Understood, Judge. Thank you.
All right, thank you.